Welcome. My name's Joe Cordell, and you've just joined us on the show Cache Counsel. We're on the DadsDivorce website now. We hope to be here regularly. Some of you have seen me on our show DadsDivorce Live, in which we talk about divorce issues related to men and post-divorce issues related to men. And really, we're kind of on the same topic to a great extent as we do this show, is we recognized that guys who are in the situation where they're facing divorce or they've emerged from it, they often are concerned about threats to their assets. Now, specifically, there's threats posed by their spouse, soon to be ex-spouse. But apart from that, they're concerned about other issues that relate to their assets. Some that may have been triggered in the process of divorce, meaning creditors that have come calling, or there have been changes of title that may have triggered the attention of potential creditors, etc. So divorce itself, to some extent, raises these issues. But apart from that entirely, I think that this is a subject that's relevant to guys. That's what DadsDivorce hopes to do, is to address things that are relevant to men's financial safety as well as the safety of their children. And we thought it would be good to do this show and do it periodically. We'll see to what extent you think it's helpful. Ultimately, you're the one who will determine if we keep this show or not. So we'll try to make it interesting. We'll try to make it relevant. To the extent that we need, we'll bring in guests, people who are authoritative in this area. Certainly divorce lawyers deal a lot with asset protection issues, and I particularly may deal with them more than some. But to the extent that we bring in lawyers who focus in that area exclusively, then we'll be happy to do that, and we think it'll enhance the quality of the show. I think a good place to start here is to discuss what is asset protection and how is it relevant potentially to you. This whole subject of asset protection has gained momentum in recent years. You've probably heard the phrase bandied about. And many people don't have a clear understanding of what that means. And to be honest with you, a lot of lawyers don't have a clear understanding of what that means. It's a very esoteric area of the law that many lawyers do not deal in specifically. Now, there are lawyers who deal in estate planning, which in a way is related to asset protection. There are lawyers who deal in divorce, of course, and that deals with some of the areas of asset protection. There are creditor lawyers, debtor lawyers, bankruptcy lawyers. I mean, they too deal with aspects of asset protection. But there aren't a lot of lawyers who focus their practice exclusively on asset protection. So as a result, this issue potentially falls between several chairs. So what we want to do is familiarize you with this area of the law, and then you can decide to what extent there's someone in particular that you'll seek out for your particular needs. And if you do research, certainly we could make referrals to the extent that people are in areas where we can't be helpful. Certainly we're glad to make referrals. But you can seek out people who can help you. So that's not my point. My point is, though, that there are not many lawyers in America who define themselves in terms of asset protection. So now let's kind of move to the next phase of the discussion. What is asset protection? Asset protection is really focusing on what things you can do, what tools you can avail yourself of that will allow you to combat potential predators. A phrase that's commonly used to describe the asset protection domain is it's intended to protect your assets from creditors and predators. So what that means is any potential threat to your financial well-being is intended to be captured in the estate plan, in the asset protection process. Now let me distinguish that from estate planning. Estate planning, there's a focus, there's a concern about creditors and predators, but it's more in the context of your descendants or your beneficiaries, your children, others, maybe your surviving spouse. It's in a little different context from protecting you as you go about your day-to-day business for the balance of your life. And of course, asset protection concepts extend beyond your life. But it's intended to be something that has a here and now relevance in a way that estate planning does not. So asset protection focuses on any source, any direction from which there may be threats to your financial well-being from predators or creditors. Let me hurry now to exclude a couple of potential creditors/predators that are not going to be included in this definition for reasons I'll explain. Not included in this, generally speaking, is the IRS. I think that to the extent asset protection lawyers start trying to devise mechanisms or entities or trust relationships that are intended to outsmart or undermine the IRS, then they're on very shaky ground. It's an area where the IRS has vigorously been active in opposing and even prosecuting to the extent possible, or encouraging the prosecution criminally where they could. So it's an area that is fraught with peril, not only for the lawyer, but also for the client. So very savvy, very informed asset protection lawyers are generally not going to have as the centerpiece of their plan the avoidance of taxes. And that includes state as well as federal. Again, I'll make this clear. The IRS has determined that they're going to target asset protection trusts in particular, but the various ruses, and you've read about these in the newspaper, where very absurdly imaginative efforts have been made to create entities that bypass entirely income tax liability. The IRS has shown a determination to pursue those, and they have successfully. A number of them have been overturned. There have been some prominent lawyers that have been criminally charged. There have been lawyers who have been disbarred. Clients have been hit with huge penalties. And who does the client turn against when that happens? The lawyer. So the lawyer is dealing with an attack not only from the legal system, but also from their client and their state bars. So I don't want you to think that asset protection has as its centerpiece minimization or avoidance of taxes. Now, don't get me wrong. There may be an opportunity, clearly within the bounds of what's permissible with the IRS regs and with the tax law, to minimize taxes, and that's perfectly okay. But most asset protection planning does not have as its primary concern that particular predator/creditor. Okay. Another area let me speak to specifically is what's considered within the domain of fraudulent conveyances. A fraudulent conveyance, as the term implies, is intended to escape someone who has a bona fide claim for payment of a debt. Now, a fraudulent creditor is typically someone who is a present creditor, although strangely enough, you can have someone where there's a fraudulent transfer relating to a creditor that doesn't exist at the time of the transfer. That's a future creditor. But really, the definitions that you see in state statutes and you see in the bankruptcy code relate to an attempt to hinder, defraud, or delay creditors. So any transfer that has as its purpose to hinder, delay, or defraud creditors is probably going to be considered a fraudulent conveyance. Now, various states have their various common law conveyance statutes. There's also some uniform conveyance statutes. There's a Uniform Fraudulence Transfers Act, which has been adopted by a number of states. There's a very similar fraudulent conveyance or transfer act related to bankruptcy law. And what courts look to determine whether or not there's been a fraudulent transfer is whether or not there are certain elements or badges of fraud. These badges can relate to secret transfers. In other words, transfers that you try to conceal. Fraudulent conveyance can relate to a transfer to an insider or a family member where you continue to have utilization or access to those assets. It can relate to a transfer in which you don't get adequate consideration, meaning you're not paid something that is commensurate with the fair market value of what you transferred. A transfer that leaves you in its wake insolvent or unable to carry on the predictable financial needs of your current obligations. A fraudulent conveyance, and this is with respect to future creditors as well, can relate to a transfer where you clearly have taken steps to leave yourself with so small amount of capital that you cannot possibly carry on your activities, or debts that you anticipate coming in the near or not too distant future. Those can be considered a badge of fraud. Now, these are kind of general principles, and I can say much more about it, but I just want you to get the idea that those transfers that are intended to outsmart or hoodwink an existing legitimate creditor are not going to be protected by the asset planning process. That's not what it's intended to do. Now, there are some lawyers who've tried to be very creative in this way. Many of those have failed. A few may have escaped capture, but the point is, it's not something that any reputable lawyer is going to want to place their license on the line or their reputation on the line or their client's best interest